cases. Where is this Uchaja Shukla? Yes.
I tried to get in touch with him. He's saying he's in hospital. His father is unwell, and I'm unable to get in touch with the concerned standing council either. My apologies, my lords. My lords, may please have it on Friday or the next.
We'll get the chief secretary on 19th.
My lords, it may not. I quite see, my lords, this is embarrassing, and I'm quite aware that.
You should have made some alternate arrangement. We are not. I think we are the most accommodative. Whoever seeks any adjournment on any ground, we are always willing to accommodate. But in such an important matter, the least that was expected was at least to make some alternate arrangement or seek an adjournment.
सभी साथी जुड़ जाएं. नेक्स्ट अभी यही नंबर है. अभी एडवोकेट साहब आ गए हैं एनओएस की तरफ से. आप देख ही पा रहे हैं गोपाल शंकर नारायण, मनदीप कालरा जी, और रेस्पोंडेंट की तरफ से उत्तराखंड सरकार है. आप देख पा रहे हैं अभी शुरू ही होगा जस्ट नेक्स्ट.
Malas may not summon her in.
My order did it.
Malas, may I submit, Malas? Just a moment, Malas. Malas, I was not unmuted, Malas. I am advocate on record in this matter, Malas.
Yes. Have you finalized it as per our directions?
Malas, we are filing two compliance affidavit today, Malas, since your lordships have granted us time for till today, Malas. So we have got the affidavits, Malas. During course of the day, we are filing it, Malas. Malas, today is the last date of compliance, Malas. We have got the affidavits, Malas. We will be filing during course of the day.
Yes, of February 2025.
सभी साथी शेयर करते हैं. बॉर्डर लिखा रहे हैं. नेक्स्ट एनओएस वाला ही सुना जाएगा. सभी साथी शेयर करें, लाइक करें और सब्सक्राइब भी करें चैनल को. और सभी साथियों तक पहुंचा दें. अब जस्ट शुरू होने वाला है इस ऑर्डर के बाद. वीडियो को लाइक जरूर करें. लाइव को
within a period of 2 weeks from the date of the said order.
ऑर्डर के बाद जस्ट बाद हियरिंग होगी.
Malas, we will be filing today, Malas. We have got the, please, Malas, we have got the affidavits, Malas, since your lordships have asked us to file till 5th, Malas.
Keep the matter today also.
Please, Malas, we will be filing it today also.
You have noticed it now.
Malas, since the matter was not listed, Malas, we were not under this impression that it will be taken up. But we are filing, Malas, compliance affidavit today itself.
Who is saying that the matter is not listed?
Malas, since the time was granted till 5th, Malas, I apologize, Malas, for the inconvenience, but we are filing it today, Malas.
Is it done or not? That's a question.
Malas, I have got that, Malas, in a process within an hour or so.
Have you not read it?
Please, Malas, I have read them, Malas.
So whether it is complied with or not, that's a question that we are asking you.
Malas, we have pointed out the difficulties, Malas. We are asking some more time since, Malas, there are some procedural aspect is, Malas, that has to be gone into. And therefore, Malas, we are asking any reasonable time, Malas, in these affidavits.
What so?
Malas, some geological, Malas, the fencing, etc., which are under process, Malas, as per the Union of India's Malas directions. So we are in the process of Malas getting them done, and Malas, we are asking some reasonable time before lordships. Malas, grant me some time to file it today.
It's compliant report. Fine. 1 minute now. Please, one today.
Please.
Advocate on record, appearing on behalf of the state, submits it. This is the court had granted 2 weeks time. It was under an impression that it could file a compliance affidavit any time during the course of the day today. When the matter was specifically listed today, at least now the state ought to have been ready with the compliance affidavit. With that as it may, we carried the matter to be kept on 19th of March 2025. We clarify that any lethargy on the part of the state, this matter would not be taken lightly by this court. Shri Parmeshwar, the learned amicus, where is that newspaper report?
Chapter 4 was constitution. 23.
exclusively on camera.
It came in the newspapers also.
This book was part of the
Yes.
page 21 about
Page?
page 21, where it kind of starts fund management issues and then page 24. Speaking of the so material diversion of state property, SCAF is from the state compensatory authority.
4 point.
Page 20.
अच्छा शुरू हो गया डाइवर्सिटी के
The bottom of page 24, the last paragraph, you see, they are pointed out other instances including this. More cases purchase of iPhones, laptops,
Shri Parmeshwar, the learned amicus, has brought to our notice the report of the Comptroller and Auditor General of India on functioning of compensatory afforestation, fund management and planning authorities. To bracket CAMPA for the year ended 31st of March 2022. In the said report, the CAG has pointed out various irregularities in the utilization of the CAMPA fund. It points out that a huge amount is spent
अभी ऑर्डर लिखा है, इसके बाद एनओएस डीएलएड की हियरिंग शुरू होगी। सभी साथी शेयर करें और सभी साथी जुड़े रहें
the report
और लाइक भी करें। जितने साथी जुड़े हुए हैं, 187 साथी जुड़े हुए हैं, तो एक बार प्लीज लाइक करें।
a huge amount is spent on state schemes like what is that Harela?
It's a function that is organized. It's a function that is organized.
Harela Tiger Safari work, renovation of existing buildings, expenses on personage, visits, court cases, purchases of iPhones, laptops, fridges, coolers, stationeries, etc.
सभी साथी ग्रुपों में शेयर करते हैं ताकि सभी
Utilization of the
एनओएस
CAMPA fund.
तक ये हियरिंग सुन सकें। सभी साथी कोई भी क्या आर्गुमेंट हुए,
Inadmissible.
आखिर क्या रहा, पूरी ऑथेंटिक न्यूज़ लाइव कोर्ट से सुनी जा सके। इसलिए सभी साथी शेयर भी करें, सभी साथियों तक पहुंच सके।
Therefore, direct
अब जस्ट ऑर्डर के बाद हियरिंग शुरू होगी। 5 नंबर चल रहा है, अभी 41 नंबर है। जस्ट इसके बाद ये मेंशन किया हुआ है कि भाई कल के लिए के लिए मेंशन किया हुआ है।
The state and about the interest of balance the staff and scrutiny of record the state about insurance state government did not discharge the interest liability of 275 crores for the period from 1920 to 21. Even though the state government request the state government to say from time to time, the state government access the facts have stated that the interest liability of 103 crores has been deposited. So two problems. That means 250 crores is actually not utilized because it was lying somewhere, not being utilized. The interest on which should have been actually credited to the SCAP and utilized for the state, that also is underutilized.
what is the full form of SCAP?
State Compensatory Afforestation Fund.
Very good. The report further points out that though as per section 4 into bracket 5 and 4.4 bracket 6 of the what is CAF Act compensatory afforestation fund, though as per so and so of the compensatory afforestation funds act into bracket CAF Act, the state had to deposit the interest on the balance available under state compensatory afforestation funds into bracket cap at applicable rate of interest, the scrutiny of records of state authority showed that the state government did not discharge the interest liability of rupees 275.34 crores for the period between 2019-20 to 21-22. It is stated that even though the state authority had requested the state government for the same from time to time, the same has not been done. The report further shows that the government has accepted the said fact and stated that in July 2023, the interest liability of rupees 150 crores has been deposited in SCAP. The Campa fund is to be utilized for increasing the green cover poster. Utilization of the same for non-admissible activities and not depositing the interest as per the provisions of the Act with the SCAP is a matter of serious concern. Very good. We therefore direct the Chief Secretary of the State to file an affidavit on these aspects by next date. Where is he gone now? Now, madam, you are present here. If you don't get a satisfactory answer on 19th, your Chief Secretary would be here on 20th.
Personally, and speak to Mr. Shakil as well.
Yes.
Manas, I am here, Manas.
Yes, we hope that you have heard the order.
Please, Manas. We will satisfy your lordship.
Satisfied now?
Manas,
This is a compliance report and you are saying that you will satisfy.
Manas, last order says, Manas, we have to file by 5th, Manas.
Today is 5th March.
Grant me any reasonable time, Manas. We are filing it today, Manas.
The list that is expected is that you should have come with the compliance report when the matter was being heard.
Manas, we are filing it today. Manas, me grant some more reasonable time. Since your lordships are taking on 19th, Manas.
Yeah, ले लो उनको.
I am deeply obliged.
अब शुरू हो गया, सभी साथी जुड़ जाएं. NIOS वाला शुरू होने वाला है जस्ट.
It's a real matter, which have been delayed 6-7 times. We are covered by this.
Yes, who is for state of Uttarakhand?
This lady, she's there. She's there for the state.
Don't address this lady directly. It's not a. Yes, madam. Have some decorum when you are addressing the board.
So, state is.
Yes, madam. Who is appearing for the state? Yes, the other co-accuser has already been granted the benefit.
Yes, ma'am. That's in this case, madam, it's listed before the Honorable High Court for final hearing on 24th of March. Madam, it's a case of kidnapping and rape of a minor child.
The learned counsel for the state.
We are covered in the election.
He had submitted the
कोई केस
That
बीच
is
में
already
मेंशन कर दिया था.
so final
जस्ट वही शुरू होगा. अपने वाले
Before-
एडवोकेट खड़े हैं, आप देख सकते हैं दोनों तरफ से. NIOS DLED
High
केस है, वो ही शुरू होगा. सभी साथी जुड़े
on
रहें,
24th of March
सब्सक्राइब करें और चैनल
2025.
वीडियो को
We therefore
शेयर
request
करें.
the High Court to take up the appeal of the said date and impose the matter on 1st of April. If it is not taken up that day, you tell us, we will consider it.
अब शुरू.
Yes, Mr. Commander.
If your lordships have the paper book for 41, so I can trouble you to take the IA, my lord, 37419 of 25, which is filed in that. Your lordship will find the papers there. Once your lordship's clarification orders dated 10 of 2024. It's at page 45
Of the IA.
of that. Page 45. And it's a reward. at 46. I can just read that short order. Page 45, 46, para 1.
Yes, please.
Yes. The grievance sought to be raised on behalf of the review petitioner of some of the applicants in the full scope is that though they were in employment covered by the recognition order in also, they believe that the judgment and order dated 28th November would come in their way if they were to make better their prospects by applying either in other institutions or for promotion level. We have already clarified in the judgment of the region that the one-time scheme was provided solely to safeguard the interests of those teachers who are employed on so-and-so day. We are therefore not inclined to entertain the present review petitions as well as miscellaneous certificates. However, to avoid confusion, we again clarify that the 18 months diploma obtained by such persons who were in employment as on 10th August 17 and who have completed the diploma course of 18 months would be treated as valid diploma holders for the purpose of applying in other institutions or for promotional avenues. Needless to state, the clarification will be effective from the date of pronouncement of the judgment under review. The date of the judgment under review is 28th November 2023. Now, the advertisement in question pronounced here is 29th May 2024. Please note that it's 29th May 2024. And that was for 2,900 vacancies for which a recruitment advertisement. 29th May 24.
29th May 24.
20. And Jaivir, so his principal judgment is 28/11/23. So since this clarification applies from there, we have the right to be considered towards this advertisement and for the counseling processes that start. A similar issue rose with reference to Bihar, in which
You were in employment on 10th of August.
no problem. We were in employment in 2017, no cavil on that count, it's admitted. We were in service and we have done the 18-month course as required by the timelines provided under the RTN. All that is not in dispute. Now, in Bihar, when the same issue arose, it came to this court, and if your lordship will see at page 52, just 10 days after your clarification out of 10th December, 20th December. Implementation of the clarification. That's at page 52, annexure 8 to 20th December. An application was passed. I had occasion to assist the board. At page 53, in fact, at the top of page 53, second sentence. Since the Bihar Public Service Commission had issued an advertisement of 7th February 24 for recruitment so-and-so, which is to commence from 23rd December. It is submitted that around 36,000 candidates are in the fray. And the present application is made in behalf of around 215 applicants as well as the stand of the NCT and the NIOS is both recorded there.
They are supporting you, yes.
Yeah. This one. So para 4 extracts the clarificatory order clause. Para 6. In the interim, we deem it appropriate to allow participation of the applicant in the counseling process being conducted by the BPSC. The outcome of the counseling process, so far as the applicants are concerned, we kept confidential. This is made subject to further orders to be passed with this applicant. Now, if I can pause for a minute and bring you up to speed what's happened in Uttarakhand. After that advertisement, they've had a series of counselling that are taking place. In the counter affidavit, because this application is coming up after notice. Notice was issued in the transfer petition first, and then in this IA. The notice in this IA was on 19th February, after which they have filed the counter, the state. Now, in the counter at page 11, the state says that the counselling process is 90% complete. Independently, we find an article and we find at page of the same application at page 95. You'll find there are 278 vacancies at the moment. I'm not troubling your lordship with the pages of the reply. No, that they can leave. Just as of the same application, page 95, it's an RTI response. The relevant is at page 96. Bottom of page 96, very last row, it says total number of vacant posts. Last column is 278. So 278 is the number of vacancies. Now, before your lordships, I represent 239 of them. I believe that without in any way disturbing those who have already been counselled, etc., which I would be entitled to ask for, but I don't want to ask for that. Let's not disturb what's already happened. If you've counselled 90% of them, you have 278 present. We are just seeking implementation of your Lordship's order. I have copies of a list which shows how your Lordship's clarificatory order post that these have been implemented in the other states of the country. Just in the other side. We've just done a little bit of a deep dive to find out what the other states have done. So post your Lordship's order of 10th December 25th. Punjab has implemented on 2nd January and then again on 4th February. West Bengal has required an order from the High Court 13th January. That's for one individual, West Bengal. Bihar has done it on 7th February and this order also in the Lordship saw. Jharkhand is 10th February, Chhattisgarh 12th February. The KVs have done it on 13th February. NCT has issued a letter also on 27th January. Now, in this line, I believe that the same order should be passed where we can be accommodated. Because that's the reason that we are the same petitioners who came before you in that review. Same people who have got the benefit of that. Now, at the very least, that should be implemented by the state. I don't know why they're dragging their feet on it.
Yes, madam.
My lords, I did not have the benefit of appearing before my lords when the parent judgment and the review order was passed. But my lords, what is being sought right now is a clarification as to interpretation over the review order.
No, they are only seeking the implementation of our review order, which we have clarified by the review order. We did not enter in the review, but we clarified our order.
To the extent, my lords may kindly see the review order and rather enlighten us as to what will be the interpretation, my lords, because the state will be is in compliance of the parent judgment, who are which basically upholds my service rules. My service rules are in consonance with the guidelines.
Therefore, we held that the special scheme was in order to protect those persons who were already in service on such and such date.
My lords,
We have, I still maybe distinctly recollect the judgment. The correspondence between the government of India and the various authorities, the NIOS and all that, was to provide avenue to those persons who are already in employment, so that they are not thrown away. And they had to complete the 18-month course online and all that. So if these persons were already in employment on 2007, then our clarification will come to their benefit.
Clarification, if my lords could kindly see paragraph 3, which is the cause of concern. If my lords could please see paragraph 3.
And you did not have, maybe you did not have the benefit, but Mr. Sethi had the benefit of arguing that matter.
My lords, the matter now, I'm the,
Yes, sir.
I'll be back the matter, so I may not be able to
And
give assistance.
Yes, we upheld his arguments.
My lords, may kindly see
Para 3.
However, to avoid any confusion, we again clarify that the 18 months diploma obtained by such persons who were in employment as on 10/8/2017 and who have completed the diploma course of 18 months would be treated as valid diploma holders for the purpose of applying in other institutions or for promotional avenues. So the purpose, my lords, my limited understanding is that it had to be for institutions or for promotional avenues. At the same point in time, by the parent judgment, my lords upheld the rules as well.
So therefore,
My lords, the new fresh counselling has happened as per the rules.
So therefore, if there are any vacancies to be filled by the state government, and they are already working in some institution on a cut-off date, then they are intended considered for migration from one institute to another institute, or if they are in the state government for the purpose of promotional benefit.
My lords,
And if you have 278 vacancies, what is the we don't say that you appoint them. You consider them their claim.
Maharaj, none of the individuals up till now, we have received any submissions with respect to what already there that any individual was removed from service or denied promotion as a direct consequence of the parent judgment. Please see my rules, my lords. My rules have been upheld. My lords, please see paragraph 15, my counter affidavit, and see the rules.
Madam, we have upheld, but at the same time, we have also clarified that all those persons who were in employment as on 10th of August 2017 will be considered as having an eligible diploma if they have completed 18 months for all purposes.
Manoj, for the purpose, that's what I seek Manoj's clarification, since it said promotional avenues, which basically would have meant that in the
In
second.
other institutions would also include the government.
Manoj, Manoj, will kindly see my limited submission. Would it also mean for the Uttarakhand government?
Yes.
That Manoj will kindly see. As I said, my lords, the judgment was passed by my lords, and I will be just seeking my lords. Rather, it's the other way around. I am seeking my lords' assistance. Manoj, will kindly see my counter affidavit.
We will provide you the necessary assistance.
My lords, guidance, a better word. My lords, paragraph 14 and 15
Paragraph.
is my counter affidavit. My lords,
By
see the predicament. My lords, just see the predicament.
we are not directing you to appoint them. We are only directing you to consider their claim.
My lords, which would tantamount to what all the process that has happened up till the counselling.
We are not touching their counseling process.
He has been very clear on that. He has himself said limited to the vacancies which are left out now.
So my lords, in which case all I'm left with is passing of issuance of joining letters.
No, consider them. Counseling you.
My lords, but merit list would go.
We are not, madam, you should have been attentive to what they said. Mr. Shankar Narayan was candid enough to say that he doesn't want to disturb the process which has already been completed.
I could say, my lords, but my instructions are this, that if you're going to consider and open it for these candidates that my learned senior is appearing for, it would have an impact on the list that has been prepared and the counselings that have.
When he is also requesting that there should not be impact, and when we clarify that there won't be an impact on the selection already done.
My lords, the process, if my limited understanding would be that if there are X number of candidates and the Y are being added to the pool, the list will have to be looked into.
Even if you clarify it under 142, not a binding on it.
Very well, my lords. Very well.
Why I don't know what has happened to the state of Uttarakhand today.
My lords, may I clarify, my lords? I'm just
We'll have to pass a cumulative order inviting you a chief secretary.
My lords, that will be not needed. If my lords may kindly
So he
consider.
has been a candidate. You are saying you will have to disturb the
My lords,
selection already done.
I'm just, my lords, perhaps buttress my case with respect to the technicalities. However,
There is no exam eligible you come. Now, if they had a question of a glut of applicants, then there may be some issue they face. At the moment, there are 278 vacancies. We are 239. If Ms. Shukla is right, they will have to open the door and just appoint us. That's exactly what will take place. But these are the applicants we were lordship just seeking enforcement of your
No,
law.
appoint us if you are otherwise eligible. Otherwise eligible and we don't know. They might be having an interview process.
If you're not eligible, then the question doesn't arise.
That's right. That's what it is.
The applicants have approached this court for a direction to permit the applicants who are holding the 18-month DED qualification, DELED qualification from NIOS under the online diploma, what is line? OTL,
EL,
Online distance learning.
Open distance learning.
open distance learning,
Open distance.
learning mode to participate in the counseling process and for appointing to the vacant post in ongoing recruitment. Paragraph. These are the checkered history. Paragraph. What is the date of our judgment?
Original judgment is 28/11/23, clarified on 10/12/24.
While our judgment and order dated 20th of November 2023, we had upheld the rules framed by the Uttarakhand government, which provided that for being eligible, be appointed as teachers, it was necessary to have a diploma course of 2 years
Or equivalent.
or
So the question also.
or equivalent post. However, in the judgment itself, we had clarified that the scheme was initiated by the Union of India for providing we had clarified that was done in order to provide one-time opportunity to such of the teachers who were already in employment on 10th of August 2017 to get a qualification of a diploma course. We are also held that the deadline of 18 months, the period of 18 months was specified in order to meet the deadline of appointing the teachers under the Right to Education Act, so and so. Correct. It appears that there was some confusion in some states and therefore review applications were filed. We declined to entertain the review application on the ground that the judgment was clear enough and it held that one-time scheme was provided solely to safeguard the interests of those teachers who were employed as on 10th of August 2017. We further clarified as para 3 and 4. The grievance of the petitioner is that though they are eligible as per the original judgment of this court dated 28th of November 2023 and the clarification dated 10th of December 2024, in as much as the advertisement is dated
29th May 2024.
29th May 2024. That is, after the judgment was delivered on 20th of November 2023, the state is not considering their claim. It is submitted that in the reply given by the state government, it is stated that the selection process is already complete and therefore the claim of the petitioner cannot be considered. Sri Narayan further submitted that. Narayan further submitted that the information received under the Right to Information Act would reveal that there are 278 posts vacant and the number of applicants is 265. 39. Correct. 3. Narayan fairly stated that the applicants do not intend to effect the selection process already done. Correct. Ms. Vanshija Shukla, the learned counsel appearing on behalf of the state, on the contrary, submit that while the judgment dated 20th of November 2023, this court had upheld the rules of Uttarakhand state, which provided that the 2 years qualification was 2 years, the diploma in education of 2 years duration was necessary for being appointed as teachers. He further submitted that any interference at this stage would cause the complications in the selection process already done. Correct. No doubt that we have upheld the rules framed by the state government by our judgment dated 20th of November 2023. However, at the same time, we had clarified that such of the teachers who are already in employment on 10th of August 2017 would be entitled to the benefit of one-time scheme floated by the Union of India. And if they had completed, we held that such of the teachers who have completed the diploma course of 18 months would be treated as valid diploma holders for the purpose of applying in other institutions or for promotional avenues. Very good. Additionally, other institutions would also include the schools run by the state government. find that the case of the present applicant would be considered by, would be covered by our clarification dated 10th of December 2024. We therefore direct the state government to consider the claims of the applicants in accordance with our judgment and order dated, and our clarification dated 10th of December 2024. And if the petitioners are found to be eligible, the applicants are found to be eligible to appoint them in accordance with law. Paragraph. We further clarify that while doing so, the state should not reopen the selection already done and which have reached finality.
My lords, also, if the contempt will not be pressed because now placing them, my lords, if it's just
So you can dispose of the, no, this is a transfer application. So now, in view,
We have find any contempt that I know.
then maybe not strata, but without contempts by identical situation.
That's not.
That's in a different.
My lords, if at all, then in that case, for
But
the
these-
different
so this is a transfer application. So transfer is sort of what a writ petition.
Yes, none of us have.
You can now withdraw the writ petition itself in way of saying.
The lordship can treat this transfer petition at discourse.
Yeah.
The main transfer petition can be.
So,
But this can be made time bound.
the service shall be done within a period of 3 months from today.
my lords,
Very good.
little more time, my lords, want to be granted because, my lords, I know my lords.
I was asking for a little less.
My lords,
The session will start, the children have to study.
my
The
lords,
new academic year.
If we invite your chief secretary on 19th, it will be done within 15 days.
my lords,
If you want, then we'll do it.
my lords, I would not be able to.
It's only with an intention to expedite the whole thing, that's what it is.
Very good. So उसमें ये लेना transfer application is also taken on board. Very good. In view of the aforesaid order, no orders are necessary to be passed in the transfer petition. Very good. We further find that the grievance of the petitioner would stand, the grievance of the petitioner as raised in the writ petition would stand satisfied with aforesaid observation, and the writ petitions also stand disposed of in terms of the aforesaid order. So there is no question of contempt.
Mr. Kalra is appearing before this High Court as well. That's what I'm saying, and you've made that assumption in the other matters also. We will comply with them if time needed. Let's go to Mr. Kalra. Great.
What is this other shift?
It's similar. The only difference is coming from Bengal, where there was a judgment of the High Court against which we filed the SLP. The High Court judgment came prior to your Lordship's clarification, but after the advertisement. So the High Court judgment effectively followed what was the main judgment without the clarification, thereby shutting us out. We filed an application, which is 19548 of 24. It's part of the SLP itself on behalf of, 199,548. This is, I'm referring to 43.1. 43.1.
43.1 है ना?
43 is a transfer petition that's dealing with UP Bihar. 43.1 is the Bengal SLP. And yes, there are companion SLPs as well. Cases.
Page number?
43.1, the recruitment notice is dated 29th September 2022. And that notice, in this case, included us, included DLed 18 months. Therefore, we were eligible, we applied, we participated. The challenge to that notification was taken by those who were the DLed 24 months, saying that we shouldn't be permitted to participate at all in the process. That writ petition first went to the single judge, and the judgment was passed on 29th February 24, allowing their writ petitions against us. Went to DB, impugned judgment is 24th July 24. sustaining the
So
same.
they had taken a view, contrary to the view taken by the Uttarakhand High Court.
Yes, they had. So they had gone with the point that there is equivalence effectively. Therefore, we are permitted to participate in that process. But the single judge and decision bench concurrently said, no, we are not permitted. Now, in view of the clarification, all of us are, in my SLP, there are 388 in the SLP and 240 in the I think this Makija is representing a larger number.
All in all, it would be about 600 or 650 or something like that. And there are 2,200 vacancies as of now.
We are totally 1,024 from what I understand, all of us put together, Mr. Prasad, Cindy, all of us put together. So we are seeking, Manoj, similarly, that because in both Bihar, that clarification has been understood properly. Today, Your Lordship have clarified it for Uttarakhand, and Mr. Gupta, the assistant, was there before this court on that date when Your Lordships rendered the clarification on 10th December. I don't think there should be any cavil with this issue that we should be eligible and permitted to take part in the counselling. Now, the one, and we have taken part in the counselling. Our name doesn't feature finally in the select list, but our name should feature in the select list because we weren't completely eligible. The only question was eligibility, which we had. That's really the only issue that I had.
The ACB has also issued a clarification with regard to all the states.
Yes, NCT was supporting you.
In fact, NCT brought along the scheme with regard to against.
No, actually, it's to the Union of India. Because that was in order to complete the deadline under the Right to Education Act. But all are you are in employment in 2007.
There's no question. It's the same issue. But I just want to give you the complete picture. There was a challenge in a separate batch of petitions between those who had the DLED qualification as in 2022 and those who achieved that qualification after a month or so. Both 24-month candidates, interstate between the 24-month candidate. There was an issue which was raised, which the High Court held against the people who did not have the 24-month qualification. And that has come up in an SLP. The matter has been heard and judgment has been reserved. Now, in that issue, it was dealing with the same advertisement. Different issue, same advertisement. In which this court passed an order on 29th January 2024, accommodating those from the 24-month DLA who had the qualification prior to the advertisement date. So 9,533 of those posts have been filled up from the entirety of 11,758. 750. So out of that 2,000 balance remains. We believe that we could be accommodated against that. I just want to let you.
Who have been accommodated? Those who are having 18 months diploma or 24 months diploma?
So month was 24 months in that case. So their 24 months before date of advertisement have been accommodated 9,500. There is a small bunch who are achieved the 24 months after the date of the advertisement. The arguments I heard Mr. Gupta, I was there, it was heard, judgment has been reserved in that. I want to give you the full picture. And
So should we aware?
judgment has been reserved. 24 months was 24 months. That doesn't have anything to do with
24 months. So there is no issue of 18 months there.
that issue. Is not. The complete picture, that's what they said.
Not accommodate the word, suitable word would be that they've been appointed.
Number of points.
Not accommodate, because there's no concession that has been given.
That's correct.
No, they have not.
That's
But against us only on the issue of JV was because only JV was not as is a clarified was. Therefore, it should be allowed. That's a short submission.
Where the Calcutta High Court relies on JV to file.
Yes. Page 4.
It's only based on JV.
That's all it is.
If they are in employment in 2007 on the cutoff date,
I'm accepting your lordship's orders in the review order also. No question. But I've gone through the JV judgment also. Your lordship's recorded that batch, there is a one-time
it's only
arrangement.
only for those who are the cutoff date is I think that August 2007.
Correct.
And we are referred to the entire communication between the Union of India and the NIOS.
Great detail, Willard. Your lordship has gone through the entire process. And as I understand it, you have
And we are also well that 18 months was provided.
Otherwise, the 18-month
Yeah,
goes to not,
otherwise, 18 months is not
not an equivalent.
not an equivalent.
But for the purpose of those persons who were in service, in
And as a matter of fact, they were sent for that course by the state governments only.
But actually, my lord, the Swayam portal was something which the state government, at least in West Bengal, had no control over. They applied themselves and they went. But the consequence is a little different. I'm only going to point it out to your lordship. It has, your lordship's order, my lord, it's to be given effect to now. There is no question. The consequence is this, my lord. For instance, if I take the petitioner, SLP petitioner, Mr. Kaushik Das, he claims that he was in employment on 2017. Now, we find that he has also disclosed TED certificate at page 290 of 2022. So here is a person who under the NCT Act, under the RTE Act, section 23, would not have got employment in any institution because he didn't have TED. I'm just giving an example. So therefore, my lord, we are now a little perturbed that there may be people in this batch who have somehow got some certificate from private unaided schools. So, my lord, what we are saying is, my lord, your lordship may remand the matter back. The persons will have to be verified because there is only one appellant before your lordship in the SLP. But, my lord, when my learned friend says 300 people, then, my lord, they are coming, my lord, as my lord, leaders.
So what we'll do, we'll hold that only such of the persons who are in employment on the cutoff date,
Yes.
they would be entitled to, and that will be subject to verification by the authorities as to whether they were in employment or not.
That is whether they were validly in employment. Because, my lord, we suspect now that private schools, my lord.
So yeah, in Uttarakhand also,
Yes.
we are not direct the blanket appointment. You have said that they will be only considered and if eligible,
Yes.
then appointed.
Yes, correct. That is one aspect which I want to bring to your lordship's attention. The second thing I wish to bring to your lordship's attention, my lord, is that as far as this process is concerned, the 2022 advertisement, 11,000 odd vacancies was there, which was advertised. My lord, 9,500 odd have been empaneled and, my lord, appointments have been given. Some 8,700 odd appointments have been given. Now, in this Shomenpal case, which my learned friend referred to, where Justice Narasimha and Justice Mishra's bench has heard us out, has heard everybody out, and only little submissions are to be filed. There, my lord, it was contended by the petitioners that the rest of the seats should be for their benefit. Now, my lord, your lordship may resolve this in any way that your lordship feels, because it shouldn't be, my lord, that one steals a march over the other, etc. Then there'll be some hard fun there.
Just to respond to the TT aspect, that's a red herring that has been thrown by them, your lordships. As far as TT is concerned, 2017 was the notification. They held the examination in 21 and declared the results in 22. And even the now 9,000 persons who have been appointed, your lordships, a large number of them belong to the 22 exam. So that is,
let me explain.
so that is a red herring which they are.
No, it is not a red herring.
Of course it is.
A person may take a TET examination in 2022 and apply for future employment for the first time. But here are people who are claiming, just 1 minute. I'm not. Here are people who are claiming that they got employment prior to 2017, but are showing a TET of 2022. So therefore, my lord, if that is so, my lord, then they apparently have got employment before 2027 without a TET, which would be contrary, my lord, to the legislation. So there are people like that.
No, so whether your rules require both diploma as well as TET.
Yes, my lord, it's not my rules. Now the RTE Act has made it compulsory that after a particular date, that is, my lord, 29th of July 2011, you must have both the minimum diploma qualification and a TET.
And they could have appeared for TET even without having a diploma course.
Yes. TET is an independent examination. TET is an independent examination. You separately and get it. Now, my lord, suppose today somebody takes the TET in 2022 and applies for the 2022 batch, then they
No, we'll say, only say that those persons who were in employment on that 2017 and who are otherwise qualified, they would only be considered.
Milord, one point, Milord, I'm hesitating to bring it to your lordship's attention because it may have, Milord, your lordship would have taken it into consideration anyway. The amendment to the RTE Act, which came in 2017, was for the benefit of people who were in employment on 31st of March 2050. And so, my lord, actually this scheme was for those persons who were in employment on 31st of March 2015, but had not been able to get the diploma, and they were, my lord, actually given an opportunity, this 18-month. I'm just bringing it to your lordship's attention. I do not know, my lord, whether this affects your lordship's, my lord, orders at all. But the section says that if you are in service on 31st of March 2015, then you must get all the minimum qualifications within 4 years' time. So 31st of March 2019 becomes the cutoff date for them. And this amendment is brought in August 2017. So there was only 18 months' time to get them qualified.
But now, therefore, we have already held that.
I leave it.
That takes care of
Let
that.
us respond on 3 points. The first is with reference to petitioners before my lord.
No, there is only one petitioner before you.
That's what I'm answering.
So we will say that all such candidates who are, we will pass an order in name, not restricting it to the petition, otherwise we will be flooded with, and we'll say that the state would be entitled to consider their eligibility.
And so I want to respond on that because there is something to be said. There's firstly, I think to correct Mr. Gupta, I have the SLP here. There are 388 petitioners, SLP petitioners, 388. Starts from page 7 onwards, you can peruse it. There are 388 petitioners. Now, there are many who are pro forma respondents, that's different, but I'm just saying there are 388 petitioners. Now, the point that Mr. Gupta took was that, look, we did not have a TET on the date when you were in service and you achieved this 18-month DLED qualification. You actually were ineligible to have been an in-service teacher because you lacked a TET. That's what he's saying. If I understand the argument correctly,
I have given only one anecdotal example because Mr. Kaushik Das's TET result is on record.
he's not.
I don't know about the others.
Mr. Gupta is not wrong. Mr. Gupta is not wrong on the fact that my TET result came in 2022. Why? Because they advertised their TET, which they had run in 2017. They didn't run TET in 2017. I applied. I was waiting. They didn't run it in 2018. They didn't run it in 2019. They didn't run it in 2020. They ran it in 2021 against the 2017 advertisement. I got the TET when you ran the TET. You gave me the result in 2022, so I'm clutching on to this in 2022. There's no other time I could have got it. That's one. Secondly, Mr. Gupta is also right that NCT regulations, which came first in August 2010, and in July 2011, they made small amendments. Mr. Gupta is well aware that both of us are contesting this issue on mandatory nature of TET, who it applies to, etc. That is part heard before Justice Datta's bench. Now, there the question is entirely different. That's a third question which arises. And let's not conflict that with this about whether those who are in the saddle in 2011 onwards, teachers who have been in service, all of now, whether the teachers who were in the saddle in 2011 require the TET, was it absolutely mandatory? That question is at the moment sub judice. So for the state to endeavor in this case to bring this bogey up, Ms. Makhija is right, to bring this bogey up to create some confusion where you have.
Then we will have to await the outcome of that petition.
What I'm suggesting is, let's not get into that for one primary reason. You'll also recall that when you dealt with the review petition, you dealt with a series of MAs. Two of those MAs specifically dealt with Bengal. Applicants who were from Bengal came before this very courtroom and argued this matter. The state filed a reply. And let me show you
But
that
your lordship didn't go into individual facts.
1 minute. You didn't go.
So if somebody is valid, fine, no difficulty.
The state shouldn't now be taking an additional bogey saying, I agree you were eligible to sit for the NCT 18-month course. You did the 18-month course. You qualified, the court has held you eligible to apply, not prior to you sitting for that 18-month course. Your question of whether you could have continued as a teacher with or without a TET is a bogey, madam. That I'm sorry. We have been in the saddle for 10 years, 20 years, 30 years. Today, after your lordship give this clarification, if your lordship were to employ the words that Mr. Gupta wants you to employ, which is to say that you should have been qualified prior to
No, I'm not asking.
18 months.
I'm not asking.
Then they will.
I'm only
after the
saying
order
that
tell us
subject to
they are
verification, that's all.
System only subject to verification.
Subject to verification.
And subject to verification.
Because the facts of each individual has not been gone in.
Subject to verification. Like you said,
Subject to verification as to whether they were legally appointed or not.
that's all. That's absolutely.
To be said, because this is what we are apprehending that the state will do, your lordships. Those who were registered for TET in 2017, because it is not my fault that I did not take the exam, they held it after 4 years. It is on their, it's their problem that they held it after 4 years. So I am registered on 2017, exam held in 2021, result declared in 2022, and the persons who are already employed and given employment to are also 2017 TET candidates.
Correct, that's
So
correct.
that should be
9,000 that they've accommodated
Yes.
includes the 2022 10.
Yes.
Then they shouldn't have accommodated them, they shouldn't have appointed this.
So this should not now come up as a second point of contention and a second round of litigation, your lordships.
Shall I throw them out now after this court's order directing them to appoint these 9,900? They will have to remove those people who have 2022 10.
No, I don't have to remove because 2022 TET, they have taken now.
They can't,
Some
they
reason
can't have
I-
that.
Future recruitments, they can use the TET. But is it not my learned friend's contention that they applied for and got a job without the TET?
Of course, I was in service without test for years. Well, there was no test.
So therefore,
That was not a private stand.
I don't want to get into this because each person will have a different set of facts.
He only brought it up. You only showed
In
it.
fact, we are finding that in the present IAs, they changed their stand from time
I
to time.
would suggest,
First they said
and
government school
orders
teacher.
similar to the
Then
Uttarakhand
the
order,
strike.
my lords, well, let them verify and just confirm, that's all.
That is what he is also saying.
Facts and
We will not go into the date issue.
In fact, my lord, if I may just add one more thing, my lord, my learned friend has shown your lordship one order of the Calcutta High Court, recent order, which relies on your lordship's my lord review order. There, my lord, that particular individual was in before the court, and her my lord qualifications had actually been checked, and a report had been given by the director that this is all right.
So therefore, we will say that the subject to eligibility and
Registered in TET.
no. Then we'll await the decision of the
Huge problem.
we'll await the decision of the other way. No, here the advertisement is what is the rate of advertisement?
29 September 22.
22. And the TET results were declared on 10th January 22.
No, that is not relevant for the.
No, we are not going into date now. We are only going into as to whether you were appointed on a cutoff date, as to whether your and the verification regarding your eligibility and the regular employment. Because we don't want to open a floodgate and get some fake certificate and all that.
Obviously, we will not defend that all.
In this state itself, my lord, we have had a situation where once an order was passed by this honorable court in 2011, there were hundreds and hundreds of people started coming, filing affidavits saying that I was also qualified on 20. Here also, my lord, multiple implement applications.
How many petitions are there? Total petitions.
SLPs.
SSLP, there is one.
One SLP in which there are many intervention applications.
There are many 100 intervention applications are there.
Well, this was all intervention.
Yes.
Close for orders. Draft बना के दे रहे हैं.
Won't see us again.
That we don't know.
I hope, my lord, what you will see us, but not in.
Not in this matter. Mutta we are having go home. You are already appointed. We are not going to disturb them. Good for you. It will take care of this.
This is only 43.1, 43 will have to come on another phase. That's for Bihar and UP. There's some other. The government is yet to respond in 43.
Getting to 43 के बाद में करेंगे.
Yeah. Very good. Simply